Did a little bit of research, and this is basically what you need to do to take the steps towards child custody. What you're gonna have to do is you're gonna have to file for a legal separation, because without the separation being legal, there's no paperwork to be filed. There's no necessity for child custody at all. So first you have to file for a legal separation. As far as I know, y'all ain't legally married, but you have to formally file for the separation. So in order to do that, what you want to do is you want to what they're going to require you to do is you go down to the courthouse, and I guess it's you ask the county clerk what office deals with child separation or with divorce and child custody, and then you go in there and ask them for the paperwork to formally file for a separation. And so in that paperwork, they're going to want the terms of the separation. So ahead of time, before you go down there to the courthouse, you want to write out the terms of the separation. And so if you make a note of these three things, this is the main three things they're going to be looking for. It's the legal custody and the visitation of the child, who's going to have custody, and what are the terms of the visitation. And then, of course, the alimony and child support is what they're going to be looking for. I know you probably don't intend to pay any alimony, but, you know, the child support is something you need to have kind of in writing or something to be able to present to the court. And then the division of property, if y'all own anything, your cars or whatever, and how that's going to be divvied up. So those three things are something you need to think about and get on paper before you go down there. It'll make filing for the separation a lot easier. So after you file for the separation, turn in that paperwork, what they're going to want you to do is take that paperwork back to Jenny and serve it to her, formally serve it to her. And what that does after you serve it to her is it gives her an allotted amount of time to respond to it. Now, I don't know exactly what their procedures are for if she does or doesn't respond to it, but I'm sure it's in your favor if she doesn't, right? But you got to make sure you serve it to her. And so after you serve her the paperwork, if she does respond to it, after she responds to it, what they're going to do is they're going to want you to come to an agreement to avoid wasting the resources of the court. So they're going to they're going to try to get you to come to the agreement, and that agreement is going to be based mainly on those three things: the legal custody visitation, alimony and support, and division of property. Those three things is what you want to come to an agreement on to avoid using the court's resources or whatever. So if you let me see, after you serve papers, you got time to respond, and then you try for an agreement. If you can't come up to agreement, then you're going to have to go in front of the judge, and then you're probably going to have to hire an attorney or whatever, and that's going to cost, it could take months and even up to years and a lot of money, and it's well worth fighting for, of course, because it means a lot to you, but only if it comes to that. I think the main point here is that if you can reach an agreement, no matter what kind of sacrifices you have to make, it's going to save you a whole lot of time and energy and hurt and pain trying to move on with your life in a kind of way. So trying to take an objective approach to coming up with an agreement with at least those three basic things, if not other things that, you know, are important to y'all or that sort of thing, is probably the best way to go about it. And so maybe talking about that agreement ahead of time would be the first step towards filing for custody. And then as you see that you may or may not be able to work out some kind of agreement, then you need to take the steps of writing out the terms and going down to the courthouse and filing the paperwork for separation. That's it. You can kill it.